first case to come before the court today is State versus Lundy. The court is prepared to hear the arguments. Are both sides ready to go?
Yes, ma'am.
Okay. You will have 15 minutes each, and you may reserve up to 5 minutes if you so wish.
Thank you, Judge.
Just let me know.
Attorney Mike Callow, on behalf of Jeffrey Mack Lundy, I'd like to reserve the maximum possible time
That would be 5 minutes.
for rebuttal.
Okay.
In this case, on December 7th, 2004, on the second day of trial, Jeffrey Mack Lundy was convinced to participate in a change of plea hearing. That was the first time in a long pretrial litigation that he ever made an effort to, through the change of plea, take responsibility or admit any guilt. Within approximately 40 days of that solitary event, he started a process that has lasted over 12 years of denying any guilt, any responsibility for the actions in the alleged criminal case. It has encompassed multiple appeals, multiple lawsuits. He sits on a 23-year prison sentence where every day he attempts to convince somebody in some court or some judge to give him a chance. And that's why we're here today.
Well, and that brings up the main issue, which you just said for the past 12 years. He sits every day, he tries to figure out some way to get somebody convinced or to file something or whatever, that this is all barred. Because it has either been litigated or could have been.
So there's an argument for people like Mr. Mack Lundy, there's always an argument made by the state of Ohio that regardless of the merits and regardless of the force of justice involved and the equitable arguments, procedure and legal procedures say no more. There's always that argument. And the state of Ohio does another job in this case of presenting that same argument. I would ask the court to consider that when he makes an argument of a structural, problematic piece of justice, like in this case, that he was never in his change of plea told or advised that he would waive his rights, his constitutional rights, that is such an argument that justice should prevail, even though procedurally this has gone on for those 12 years. And there's lots of other cases that we learn in law school of those types of things where someone challenged the system for 10, 20, 30 years and finally got to some court who said, you know, that makes sense and justice needs to prevail. And in this case, it's really that type of an equitable argument that in this particular case, as the facts are, he is crying and at points uncontrollable during a change of plea. A judge reads to him certain constitutional rights that he has, which are read to every criminal defendant in a change of plea. But in this case, what never happens, when you look at the merits, what never happens in this case, is he's told those rights are being waived by doing a change of plea.
Is that because the word, are you arguing that that's because the word waived was not used?
Not only not waived, but no words like waiver were ever used.
Nothing like given up?
Given up, you're not going to get that, nothing like that. What happened was in this what must have been an incredibly emotional change of plea, from my understanding, I was not there. You know, the defendant is curled up at one point in a ball crying. The judge is reading to him, here are these rights. You know, you have the right to this, you have the right to that, which is very standard. But the judge never says to him, do you understand you're waiving these rights or you're giving up these rights? Or by going to a change of plea, you won't get the benefit of these constitutional rights. So it's not just the magic word of waiver, but that concept was not brought forth in other words either. And Mr. Mack Lundy is over 12 years, yes, coming up with every argument he possibly can to get back to a trial. And this sounds to be a good one that he's hoping the court recognizes, that such a problem occurred in a change of plea that you cannot avoid it. And he's hoping that this court will take note of that and give him an opportunity for another trial.
So, assuming you convince us to do this, what's our legal, what's the legal analysis? Is it that if you are sentenced to a long term of prison and you fail to raise these issues at the earliest time at your direct appeal, and then, you have these other, motions to vacate and so on and so forth, that if you just keep going and keep going and keep going, and if you're really passionate and emotional about it, that a court will eventually, grant you your request. And what does that do to all of those cases that we've had where we say, it's barred by res judicata, it's barred by special prosecutors, it's barred by, whatever, law of the case, all of which at some point probably apply to this case. How do we write that?
So what I would say is, in certain circumstances, when you look at the merits of the case, there's such a problem in the merits that you have to balance that with all these procedural safeguards. But sometimes, in some cases, the merits are so bad that it has to trump, in fairness and justice, these procedural safeguards. I understand the need of a court to say, after one appeal or two appeals, it's enough. I understand that after so many years, you might say this is stale. But at the same time, in 12 years, all of the arguments and all the defenses are procedural in nature, and we never really get to, and the court decisions, whether it be the trial court decisions or the mandamus action decisions or the appellate decisions, never really gets to the merits of the case. Nobody ever tells this man, I've reviewed your change of plea, and I'm okay with it. It's always a procedural offense, and I think this is that case. This might be that case where you say, look, this change of plea just doesn't sit right. It's not right. And even though there's procedural issues here and there, it's not right. It's not right for a trial judge to do a change of plea with a man who is emotionally unstable, crying, curled up in a ball. At one point, they bring the brother and the mother in to hold his hand so that he could participate without sobbing all over the place, and not tell him what is critical for the trial judge. Look, by taking this change of plea, you're giving up your constitutional rights. And the judge, that's his burden. The judge is supposed to make sure, he or she is supposed to make sure that that person understands it. It's not my client's responsibility, it's the judge's. And in this case, that complete failure took place. You don't just read these things. You have to come to the next step, which is the defendant understands. And if you look at the merits, it didn't happen here.
Well,
it just doesn't sit right.
The other thing, though, is even if we were to go to the merits, the state, as I understand, is saying there's not a transcript in front of us, so what are we supposed to do with that?
So, another procedural argument made in the case is that in this particular appeal, the record, all it says is transcripts were filed. But apparently the assistant prosecutors indicated that not all the transcripts from the entire case have been filed. So, although the trial judge in the case indicates in his judgment entry, and he specifically says that he's reviewed all the trial transcripts, including this one, somehow it didn't make it into now this trial transcript. So another procedural issue comes about that this is the case. This court previously had the appeal of the case and had all those transcripts. Should have been returned to the trial court when the appeal was done. This judge had it at his exposure. We know because he writes it right in his decision that I've reviewed all those transcripts. How it's not in the record, I'm not sure. I'm not sure how to explain those errors at this point. My client, again, is forced to deal with the procedural issues instead of someone dealing with the merits of the case. And this is another procedural issue that is probably error. And if the court finds that to be error, it's probably error on his counsel, which means he should then get another argument with another counsel. And I understand that, what Jeffrey Mack Lundy needs is a resolution to the case on the merits. Remember, and I ask you to consider, he's never confessed to this case. There was no confession. There was no personal identification to him being the offender in the case. There was DNA evidence on a watch that was found near the scene of the incident. And in the entire pretrial litigation, he never said he did it. Other than the one fateful day when he does a change of plea, he's been fighting for now 14 years or so, saying, I didn't do this, I'm actually innocent of this crime.
Counsel, you're starting your 5 minutes if you'd like to reserve that.
And I'd ask you to consider all the arguments made with that in mind, that the man is actually innocent of the crime. Thank you.
Thank you. You may proceed.
Thank you, Your Honor. May it please the Court, my name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. If I understand counsel's argument correctly this morning, what he's imploring you to do is to overlook all of the various procedural protections afforded to the state and to the victims in this case from having to consistently and unnecessarily, in the state's view, relitigate this case. This is at least the third separate motion to withdraw a plea that Mr. Lundy has previously filed. The first one back in 2005, the second one in 2008, and the third one in the early part of 2013. He previously tried to do a mandamus action against the trial court judge in this court in 2006, or late 2005, early 2006, which was dismissed. He tried to do a mandamus action against the trial court judge to the Ohio Supreme Court directly, which was dismissed in 2009. He then, a couple years later in 2011, tried to do another mandamus action in this court, also dismissed. Appeal of right to the Ohio Supreme Court, also denied in 2011. This marks at least the sixth attempt that Mr. Lundy has made to relitigate this issue about his plea. Enough is enough. The reason that procedural protections exist is because Mr. Lundy has had a full and fair opportunity to litigate these claims. Now, the other argument that Mr. Callow makes this morning on behalf of his client is that you should look to what actually happened at the plea to determine whether or not that satisfies Rule 11. But the court is unable to do that in this case because there's no transcript of the 2004 or 5, I believe, plea hearing in this case. It was not transmitted as part of the record on appeal. Even if you wanted to look at the plea colloquy, you would be unable to in this case. Now, there's a reason why procedure matters, because it's how we organize our affairs. It's how we structure the way that the law is reviewed. It's how the law operates. It matters for a reason. And in this case, that reason is to prevent Mr. Lundy from, as Mr. Callow very cogently explained, sitting in prison, thinking of a way every day to convince somebody to do the thing he wants them to do. Enough is enough. I really don't have much more unless the court has further questions for me. I would respectfully ask the court to affirm the lower court's decision, and I would yield back my time.
Thank you.
Thank you.
You do have 5 minutes.
Thank you, Judge. I'd like to give an argument for the procedural nature of this case. It might be a little different, but would provide you with a method for doing what I'm asking you to do. The judge in this case, specifically appointed by the state of Ohio after various recusals, indicated in his decision that he was treating this as a new post-trial motion to withdraw. And I think that is a distinction because the previous arguments made and the previous appeal addressed and challenged whether or not my client's pre-sentence motion to withdraw the plea was done appropriately or the abuse of discretion on that. But when this particular judge addressed the issue, he indicated it was a he was treating it as a post-trial or post-sentencing motion of withdrawal, which I think is opens up a new motion, it's recognized as a new motion. He then, not only does he say he reviewed all the records, which should be in the record, but then he says that the strongest argument defendant made, both pro se and later through counsel, excuse me, I have to say it wrong, is that he was not explicitly informed that his plea of guilty was a waiver of his right to compulsory process. He then cites the transcript, in fact, where that took place. He then says, he does not say that it was done. He does not say that waiver was ever used. He does not say that any concept of waiver was used. What he says is the defendant had ample opportunity to discuss the rights with the court and counsel because this took place on the second day of trial. So structurally and procedurally, if this judge decided this was a post-sentence new motion to withdraw based upon a similar argument, but it's a new motion, I think that you could hold that the judge's rationale was an abuse of discretion with this particular motion and send it back down for reconsideration of the motion, because this is a new motion. According to this judge, it's a new motion. His rationale for his decision was the defendant had ample opportunity to discuss his rights with the lawyer or the court. And I don't think that's the standard that should be applied. I think the trial judge has to satisfy him or herself that the defendant understands and makes a knowing and intelligent waiver of those rights. So I think procedurally, you could give my client an opportunity by saying that the trial judge needs to reconsider this motion under the proper standard, which is whether the defendant knowingly and intelligently waived those rights, and that having an opportunity to discuss the matter with the court or with his lawyer is not enough. And I think that's a procedural way that you could send this back down to the trial court with instruction to consider the merits of the case. Thank you, judges, for your time.
Thank you. The court will take the matter under advisement. A written opinion will be issued and sent to both sides, and you can also check on our website. Thank you.